Breaking news. Appeal Court reserves ruling on federal government stay of execution plea. Hey, oh my God, this is really very shameful. I believe by now, this AGF Abubakar Malami should have learned his lesson. Buhari should now understand that the reason why his government is like this is because he surrounded himself with people who know nothing about the appointment is all about, what their office is all about. This is just a perfect case of defendant lecturing a whole AGF, the Attorney General of Nigeria, the rudiments of the law and court procedures. Is that not amazing? This Malami better resign before he's disgraced out of Supreme Court shortly. Because this case, it just sweets me. You see all this power. Because you feel that you are the AGF, you can do anything just like how they have been doing all this while. You invaded this man's house in 2017. Your mission is to kill him, just like what they did to Sunday Igboho too. Is it wrong for people to agitate? Is it wrong for people to protest? This government, we now found out that people don't protest. You are doing bad things, make people not talk. But this your government, now through protest, they take come office. Because they know say they are not living up to the expectations of Nigerians. So anybody when just want to talk anything, they will come after you. It's a shame. It's a shame. A whole AGF Malami, nothing no say na so law be. Then go disgrace him for here. That is it. He's being disgraced already. He's being disgraced already. What else again? Now make me talk say in shame, they shame me. Honestly speaking. Now it good. You carry your in-law, give appointment. You carry your brother, give appointment. You carry your mother, your brother, give appointment. What else? Nigerian government don't turn to family affair. They go to their bedroom, they discuss about Nigeria, what they will do tomorrow to Nigeria and Nigerians or whatsoever. This is a very good lesson to him. You cannot eat your cake and have it back. Nigeria belongs to every one of us. Nigerian constitution is not against self-determination. You cannot fight those who are killing people in Nigeria. But those who are saying we are tired, we are tired of this country. Instead of you to call them, sit down, listen to them and talk to them. One I won't come out. Okay, now like this one, make you do one like this. It's bad like that. But your people who are killing people, you pay them. They will come and tell you that they are tired. You pay them and all that. You give their children scholarships. You pay them good salary at the end of the month. Igbo youths now, so many of them, they don't abandon them for some secret cells where we don't know where them they. You see this God there, they talk and say, if in time come, nobody feel they challenge God. I believe this is the time of God. And every enemy of this country, God will disgrace them. Let's quickly hit the news and get the full details. The Court of Appeal Abuja Division has reserved ruling on an application filed by the federal government seeking a stay of execution of its judgment delivered on October 13th. Justice Aruna Samani, leading a three-man panel, reserved a ruling on the application after council had adopted their written addresses. Record that the Court of Appeal Abuja had on October 13th quashed all the 13-count charge preferred against the leader of the indigenous people of Biafra, Mazi Nnamdi Kanu, by the federal government of Nigeria. The three-man panel of the appellate court, led by Justice Jumina Sanki, having dismissed all the charges, consequently discharged and acquitted Kanu. However, instead of obeying the valid order of the Court of Appeal, the DSS has continued to detain Kanu. On Monday, the federal government told a 3-man panel of the appellate court that it had filed a motion on notice brought pursuant to Order 6-1 of the Court of Appeal Rules, etc. By the application by stay, David Caswell, the counsel for federal government, is praying for an order for stay of execution of judgment of the Court of Appeal delivered on October 13th, pending the determination of an appeal at the Supreme Court. Kwaswe said his application was based on 6 grounds and supported by a 5-paragraph affidavit. Before adopting the written addresses, Kwaswe informed the court that his application was brought essentially in the interest of justice and the need to preserve the relatively peace in the Southeast. The respondent in a flight risk person, and one of the grounds for the application touches on national security. We urge the court to grant our application as prayed, having seen the exceptional circumstances and in the interest of justice, Caswell stated. Reacting to the respondent's counter affidavit, the federal government lawyer said releasing Kanu may impact negatively on the fragile security situation in the country and the Southeast in particular. Imagine. He asked the court to grant the application, adding that Kanu is being held in the interest of national security. On this part, Chief Mike Uzekome-san, the counsel to Kanu, said he filed a 5-paragraph affidavit disposed to by Ifeanyi Ejiofor Esquire to oppose the highly
Thoughts below the comment section.
meritorious application, of the federal government. Zekome insisted that the case of Asari Dokubo cited by the federal government has nothing to do with the instant case. He urged that the essence of the federal government application is for the appellate court to overrule itself, saying there will be anarchy and chaos in the Southeast if they continue to detain Kanu. It is the release of Nnamdi Kanu that will bring peace and tranquility in the Southeast. When the judgment was delivered on October 13th, there was joy, merriment, and celebration in the region. There is no exceptional circumstances. There is no race to be stayed, and I urge the court not to scramble to the application of the applicant, Zekome posited. He noted that the federal government knew that in a criminal proceeding, you cannot bring in a stay of execution, and that was why they filed the motion on notice under civil rules procedure. Zekome said, because you can file a stay of execution, there must be a valid appeal. The applicant brought issues of mixed law and facts, and the application was filed without leave of court. In addition, Zekome urged the court to look critically at health condition of Kanu, saying that it is only the living that can face trial. He posited that Kanu did not jump bail until the federal government invaded his home, and by providence, Kanu managed to escape. He recalled that even United Nations Working Group has urged the federal government to release Kanu. He therefore urged the court to refuse the application of the federal government for being an abuse of court processes, a slap on the face of this court, an insult to the courts. So guys, I'm dropping it here. More of this will come to your way soon. Kindly share your thoughts below the comment section. Thank you.